cell phones during elections, and they have been used even in election petition tribunals. They have been received as evidence that they have been used. So that is an example of a private detective. So why don't we have the legal framework to regulate bad practice? Mr. Speaker, may I urge honorable colleagues to please support this bill, as it will make Nigeria to join the Committee of Advanced Nominations. Thank you, Mr. Speaker.
So I put a question, and the question is the bill be now read the second time. Those in favor of the motion say aye. Those against it say nay. Ayes have it.
Mr. Speaker, may I move that a bill for an act to alter sections 233, subsection 2 of the Constitution of the Federal Republic of Nigeria to expand the jurisdiction of the Supreme Court of Nigeria and for other related matters be read second time. I so move, Mr. Speaker. Mr. Speaker, our present Constitution started from 1979. And if we may recall, under the Constitution, Mr. Speaker, there are no election petitions tribunal the way we know them today. As a matter of fact, election petitions were filed in the regular courts. In the initial courts for the election tribunal, you go to the one judge in the High Court in the state where the tribunal matter arose would hear and determine that matter. But subsequently, in the 1999 Constitution, we now have a new innovation where we have tribunals. It used to be made up of 5 persons. Now we have amended it. Is now
Honorable Hassan Saleh, please.
And
go back to the seat. Go back to the seat, Honorable Hassan Saleh.
Mr. Speaker, under the present arrangements, petitions in respect of National Assembly and House of Assembly matters terminate in the Court of Appeal. It used to be the same thing too for governors. However, in 2011, this same Parliament altered the Constitution to ensure that appeals for governorship matters will terminate in the Supreme Court. Mr. Speaker, let me bring out one salient example. In Rivers State, because the appeals were altered to terminate in the Supreme Court, today, Mr. Wiki is the governor of some of our colleagues, Boma Goodhead and others. It's all the same, similar facts. So if their appeals were allowed to go up to the Supreme Court, probably our colleagues wouldn't have suffered the same fate. So, Mr. Speaker, I think it is needful to amend the Constitution in view of the mischief so that appeals in respect of such matters will also terminate in the Supreme Court. Since the governors, we've seen the mischief that has been cured when the Constitution was altered in respect of the governors. Mr. Speaker, I so move.
Speaker, honorable members, a bill for an act to alter section 233, subsection 2 of the Constitution of the Federal Republic of Nigeria, 1999, to expand the jurisdiction of the Supreme Court of Nigeria and for other related matters. Second reading.
Bill is referred to the Special Ad Hoc Committee.
Or the House of Representatives shall vacate his seat in the House of which he is a member if G, being a person whose election to the House was sponsored by one political party, he becomes a member of any other political party before the expiration of that period for which the House was elected. The party is not as a result of a division in the political party of which he was previously a member, or merger of 2 or more political parties or fractions by one of which he was previously sponsored. Mr. Speaker, these provisions are traceable to the Second Republic, specifically 1979 Constitution. It was not in our First Republic's Constitution. It is admitted that it's because of the cross-carpeting in the First Republic that led to the provision being promulgated in 1979 and is now being retained in the present Constitution. But Mr. Speaker, let us remember that this provision applies to only the legislators. What about the executives? We've had governors defecting from one party to another party. Nothing happened to them. And Mr. Speaker, we are now practicing a presidential system of government. If it was brought in to cure the mischief that we witnessed in the First Republic, let us remember that that First Republic was a parliamentary system of government where if members move from one party to the other, they can destabilize the government because the government can become either a minority government. But Mr. Speaker, in a presidential system, you can have the president in a different party and even the majority in a different party. There's no harm. So we think that in this day and age, we don't see any reason why we have this kind of provision, which is even discriminatory because it doesn't even affect the executive. The president today can even leave his party, governors or chairmen. What about no legislators and why? So, Mr. Speaker, I think that the time has come where we need to do justice by even repealing the entire section 68(1)(g). Mr. Speaker, lastly, our constitution in section 40 provides that every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political union or any other association for the protection of his interests. This is a fundamental rights provision. So, by curtailing the rights of members to even move to another party, you are even curtailing their fundamental right because the Constitution has given us any right to freely associate anywhere. So, and this is the kernel of democracy. You have the right to choose.
Good for the goose is good for the gander, or you are saying that we should expunge it altogether because it restricts our fundamental rights to association. Pardon?
We will expunge it altogether because it restricts our fundamental rights and it's also not applicable to the others, Mr. Speaker.
Okay. The question is that the bill be now read a second time. Those in favor of the motion say aye. Those against it say nay. The ayes have it. I think that section has even created confusion in the Supreme Court. I read that judgment, it didn't make sense to me.
Honorable Speaker, honorable members, a bill for an act to alter section 68, subsection 1G of the Constitution of the Federal Republic of Nigeria, 1999, to further provide a proviso on the vacation of seats by legislators and for other related matters. Second reading.
Rule 5. Mr. Speaker, sir, on Tuesday, I was in the plenary. After signing the attendance register, in order to get the documents used in the plenary, we were told the other papers are not enough. The scenario has repeated itself today again. While I came in, I signed the attendance, only to ask for the other paper. I was told the other paper has finished. They don't have enough other paper. I believe this is one of the documents. This is one of the documents we use in the plenary. I want Mr. Speaker, sir, to use the good office to direct those in charge to go and print it and serve those who have no. Right now, sir, Mr. Speaker, I think for me.
I rise to move that a bill for an act to alter section 147 and 192 of the Constitution of the Federal Republic of Nigeria, 1999, to provide that the nomination for the appointment of ministers and commissioners shall be made not later than 30 days from the date the President or the governors takes oath of office and allegiance, and for other matters related. I so move, Mr. Speaker.
Solomon, make your case.
The bill seeks to alter section 147 and 192 of our Constitution to provide a time frame within which Mr. President must forward the names of his ministerial nominees to the Senate for screening and confirmation. This bill also seeks to make it mandatory for the President and the governors to submit the names of the ministerial nominees and commissioner nominees to the Senate and the State Houses of Assembly within 30 days after they must have taken oath of office. This bill, when passed, Mr. Speaker, will require the President
and the governors to attach the portfolio for each person nominated while forwarding to the Parliament. The essence is to ensure efficient deliberation while screening to ascertain the competence, the suitability, and the capacity of every individual so nominated. Mr. Speaker, the hallmark of every democratic government is that it enjoys subsection 5, gave the Senate and the State Houses of Assembly 21 working days within which they screen and confirm the ministerial and commissioner nominees from the time of the receipt of such nomination. Of course, the roles of ministers and commissioners is to articulate programs and enunciate policies and of course implement these policies of the government. Unfortunately, Mr. Speaker, our constitution is not explicit as to when the president and the governors should submit the names of their ministerial nominees. There is no doubt, Mr. Speaker, to suggest that the president and the governors have discretion to appoint the ministers and the governors anytime, the commissioners anytime they want. But after the general election in 2015, after the inauguration of Mr. President, there was a long delay before the constitution of the Executive Council, before the submission of the names of ministers to the Parliament. Mr. Speaker, this long delay raised a whole lot of suspicion in the minds of the citizens as to the motive and the direction of the government. This long delay, Mr. Speaker, eroded the confidence of the investors. This long delay, according to Punch newspaper, also discouraged some investors particularly foreign investors, from coming in to invest in our capital market and in the aviation sector. Mr. Speaker, this long delay impacted very negatively on our economy. Mr. Speaker, the drafters of our Constitution understood the importance of the cabinet to the president and the governors. That is why in section 147 and 192, it gave the Parliament 21 working days to quickly screen and confirm these nominations for a smooth take-up of the government. The 4-year tenure given to the president and the governors is not a long time. So why waste all the time trying to, constitute this executive council?
Honorable Gudaji, go back to your seat. Honorable Gudaji, you are disturbing the dais, please.
Jurisdictions like America, UK, and Canada has revealed that once the chief executive or the president is elected, he already has a list of his ministerial nominees prior to swearing in, which of course, when that happens, he submits to the Parliament for screening. This practice, Mr. Speaker, should be made constitutionally mandatory in Nigeria to improve on the efficiency of governance in our government. Also, Mr. Speaker, this bill also seeks to make it constitutionally mandatory for the president to attach the names of the ministerial nominees while submitting to the Parliament. Finally, Mr. Speaker, in order to prevent subsequent governments from placing critical infrastructure, critical sectors of our economy at risk, this bill proposes a 30 days period within which, after taking oath of office, the president and the governors must constitutionally submit the names of the ministers and the commissioners to the Parliament for screening. And
Honorable Speaker, honorable members, a bill for an act to alter section 147 and 192 of the Constitution of the Federal Republic of Nigeria, 1999, to provide that the nomination for appointment of ministers and commissioners shall be made not later than 30 days from the date the president or governor takes office and takes oath of office and allegiance, and for other related matters. Second reading.
The House notes
that a bill for an act to establish the Federal University of Petroleum Resources, a forum, and for other matters connected thereto, 2016, was passed by both the Senate and the House of Representatives with differences. Aware that a conference committee was constituted by both chambers to harmonize the areas of differences in the bill as passed. Also aware that the committee met in conference on Thursday, November 3rd, 2016, and harmonized the two versions of the bill. In view of the importance of the bill in providing specialized training and high level of personnel required to drive the federal government's local content policy in the oil and gas industry, the House therefore resolves to receive and adopt the report of the Conference Committee on a bill for an act to establish the Federal University of Petroleum Resources, a forum, and for other matters connected there, 2016. Mr. Speaker, my dear colleagues, I so move.
Investigate the of health maintenance decisions, the moves to the National Health Insurance NHIS divisions, utilization of funds by the healthcare providers, that the National Health Insurance was set up to provide healthcare for all Nigerians at an affordable cost through various prepayment systems, and also to ensure the availability of funds to the health sector for improved service delivery. Also notes that globally, health is regarded as a social this employee pays 1.7%. The state government, the local government, and organized private sector employers pay 10%, and employees pay 5%, amounting to 15% of their monthly salary, and these monies are deducted directly from their salaries, even when the services for which the premium deductions are made are not rendered satisfactorily. Aware that the release are being shortchanged and used as conduit pipes to fund revenues to the HMOs and healthcare providers, as the release are treated like leprous people while trying to assess the services, given that many strategies have been adopted by the healthcare providers and HMOs to deprive the release of their rights to qualitative treatment and attention. Also aware that the HMOs have received over 350 billion naira from the scheme since inception in 2005, and it is regrettable to realize that the services cover less than 4% of Nigerians, which is the current coverage of the scheme. And there are reports of alleged diversions of contributions amounting to billions of naira. Further aware that the scheme pays the HMOs 3 months upfront to enable them to provide timely, standard, and qualitative healthcare services to the enrollees through timely and regular payment to the health providers, but the reverse is the case. Cognizant that the scheme's benefit packages have many mouth-watering provisions from the primary, secondary, and tertiary healthcare levels. For 11 years since its establishment, there have not been much difference because beneficiaries or enrollees are being shortchanged, services denied, confidence in the scheme eroded, and above all, the core mandate of the scheme has not been achieved. The House is invited to resolve as follows. 1, they urge the National Health Insurance Scheme, the NHIS, to put on hold further quarterly release of funds to the HMOs pending the outcome of investigations by the House. And secondly, to mandate the Committee on Health Services to conduct an investigation on the activities of the HMOs and healthcare providers for the past 8 years, with a view to identifying the HMOs, their level of compliance with the relevant provisions of the Act, and determine reasons for the poor state of services to the release, and report back to the House within 4 weeks of further legislative action. Mr. Speaker, distinguished colleagues, I so move. This motion is simply seeking to address Nigerians
who are enrollees with the National Health Insurance Scheme and whose health have been denied, hope deprived, and they get almost nothing from the service which they deserve from the HMOs and the health service providers. Mr. Speaker, my office as the chairman of the House Committee on Health Services is inundated with hundreds of petitions from Nigerians, enrollees, who have been so unfairly treated by the activities of the HMOs and the healthcare service providers. And if I begin to bring these petitions to lay here on the floor, we'll do any other business except laying petitions, considering the petitions from the enrollees. This scheme was created in 1999, but it became fully operational in 2005.
Honorable colleagues, order, please. Order.
The health of all Nigerians at an affordable cost, through ensuring that every Nigerian has access to good health, healthcare, and service delivery.
Honorable Amina Ashuru.
The scheme is also supposed to protect Nigerians from the financial hardships of huge medical bills whenever they visit our hospitals. This scheme is also supposed to ensure equitable distribution of facilities all over the country. This scheme is also supposed to manage the rise cost of healthcare services, both in public and private sector. This scheme is also supposed to improve and harness private sector participation in provision of healthcare services, and is supposed to maintain high standard of healthcare service delivery within the scheme. But Mr. Speaker, the scheme is set up in such a manner that an employer registers himself and his employee with the scheme. Thereafter, the employee enrolls him or her with NHIS approved HMO, who will thereafter provide the employee, that is the contributor, with a list of NHIS approved healthcare service providers, public-private hospitals. The employee also registers himself as and dependents with the provider of his or her choice. It is worthy of note that there is an approved health package which beneficiaries are entitled to from the primary and tertiary level. But it is regrettable to note that after the contributors' money has been deducted as source by the various agencies, the HMOs smile home with the monies they collect, the health service providers smile home with the monies they collect, while the released Nigerians are left without care and treatment. It is on record that HMOs collect the sum of 8 billion every quarter, which, if you put it together from the time the scheme commenced, it means that the HMOs and service providers have been paid well over 351 billion naira to them, for them to provide timely payment to the healthcare providers, and for the healthcare providers to provide an inexcusable standard quality healthcare services to the release. But today, the case can be described as a case of water everywhere, but no water. So my colleagues will be saving lives on this floor by our support to this motion, considering the fact that the importance of strengthening the NHIS scheme and the need for the release to get the service they have paid for, and to make sure that HMOs and health service providers do the right thing and provide quality healthcare delivery to the release. I hereby humbly ask for your support to this motion, and the prayers are adopted for the wellness and good health of Nigerians through the NHIS. Thank you very much.
The degree of treatment or the access to health management institutions that are aligned to this product, they are removed from people who have higher grade of employment. What I mean, Mr. Speaker, is that a junior worker, his treatment is proportionate to his contribution most often. His basic sicknesses, whose differential diagnosis can be spotted within 2 days. These are the issues that are treated by hospitals. Most of the hospitals that benefit from this scheme, they find it difficult to migrate a junior worker who have an accident, who is disabled, who have a chronic disease like liver problem or heart failure, that things that will take life and take an enormous amount of money to be cured. Therefore, Mr. Speaker, the removal of the motion, not just issue of investigation. If you go to the books of the banks, you see a lot of fixed deposits that are built up for HMOs. They are accruing interest in the bank, diverting such money into issues that are not related. There is no database stating the category of drugs that will be procured by these HMOs. Most often it's mostly analgesic, paracetamol, basic malaria treatment. These are where these monies are going, and the rest are being diverted for private use. Therefore, Mr. Speaker, I plead with you and my colleagues to support this motion. It will erode fraud in the system. It will give access to help to people who are contributing to the scheme without minding their level. You see, overseas, people who have been flown overseas, they are top-tier echelon of employees in the industry. Wherever they are, once they are ill, they are taken overseas for medical treatment. But our people who are producing this money, who are working in various sectors of the economy, they find it difficult to have access to health care. While whatever they contributed are lying idle in the banks. I plead with my colleagues to ensure that this motion is supported. Thank you.
Ibokwe is my name. I represent the good people of ASVICATE MBC, Federal Constituency of Imo State. Mr. Speaker, I rise to give my support to this motion. And in all intents and purposes, the spirit of the motion tends to seek for the protection of citizens of this country. Because the National Health Insurance Scheme, as we all know, was set up to provide health care for all Nigerians at affordable cost through a pre-payment system. And most of our public, virtually all public officers or public servants have deductions made in their salaries in respect of this scheme. And what this motion is trying to ascertain is the level of services given, is it commensurate with the deductions that are made? Are the workers getting value for their money they are contributing or being deducted for this issue? Mr. Speaker, another important legislative aspect of this motion, which I cherish, and I want to commend the chairman. Over time, I had observed him in critical sensitive issues, which ordinarily his committee should take up as part of their normal course of business of oversighting the health services sector. He also deemed it right to bring it before the House so that it can get the full backing, authority, legislative, and otherwise powers of the House to go into the matter, bringing it to a different plane, showing the importance and the critical value of the issue in question. So it's not and want to invite us, dear colleagues,